So the president appointed Hicken as acting commissioner of police using the doctrine of necessity. But when you look at the president's actions, the president said, well, I was forced to act in the face of, in the absence of a police service commission and in the absence of a leader of the opposition. What do you expect me to do? Do you expect me to have a police force without a commissioner at the helm? Right? That's what the president said. He doesn't give any proper reasons that would attract the doctrine of necessity. And then when you interrogated President Ali's actions, it was pretty deficient. It was pretty deficient. I'm surprised no other person, legal scholars, wrote an opinion. This is the summary of the facts that I reached in respect to Ali's conduct. The Guyana police force was without a constitutionally appointed commissioner of police or acting commissioner of police when both a leader of the opposition and chairman of the police service commission were in place. And that's between the President Ali basically started functioning as president on August 2nd or August 3rd, really. And the leader of the opposition was in place until the 26th of January, 2022. The Police Service Commission was in place until June of 2021. So that no consultation took place between the president and the leader of the opposition on any constitutionally mandated appointments that include that of the Commissioner of Police, Judicial Service Commission, Chair of the Police Service Commission, Integrity Commission, Teaching Service Commission, amongst other constitutional bodies and office holders for which meaningful consultation was necessary between August 2020 and January 2022. And you remember what the president said. He said, well, hey, I'm not talking to the leader of the opposition until he recognizes my government and recognizes the legitimacy of my party. That's what the president of Guyana said. So, and so the absence of a leader of opposition and a police service commission as the stated basis on which President Ali acted in March 2022 is not borne out in light of his actions between August 3rd, 2020 to January 25th, 2022. You can't refuse to speak to the leader of the opposition unconstitutionally and illegitimately fire the police service commission because they didn't do your bidding, and then you appoint a commissioner of police and you claim that you're using the doctrine of necessity. There was no necessity. So we say, so I wrote that the legitimacy of the doctrine of necessity as a tool to override the sanctity of the Constitution is therefore a matter for the Supreme Court of the Judicature and higher courts to determine in light of the factual matrix above. Right? And this is not technically legal. This is how you apply the doctrine of necessity. There has to be an imperative necessity that must arise because of the existence of an exceptional circumstances not provided for in the Constitution for immediate action to be taken to protect or preserve some vital function to the state. Right? That's the first prong of the test. There must be no other course of action reasonably available. Any such action must be reasonably necessary in the interest of peace, order, and good governance, but it must not do more than is necessary or legislate beyond that. That's sort of like what happened in Pakistan when Musharraf took over. It must not impair the just rights of citizens under the Constitution, and it must not be one the sole effect and intention of which is to consolidate or strengthen the revolution of as such. And that's a case called Mitchell versus the Director of Public Prosecution, a case that emerged in Grenada. And that test that emerged from Grenada was adopted even in Fiji, Pakistan, all over the place. So I said that the president provided no basis for the acting appointment except to say that this is what the president said. There is something called the Doctrine of Necessity. Should I allow the country to function without an acting commissioner? There is a Doctrine of Necessity, and in the Doctrine of Necessity, I appointed the acting commissioner. So that's like tin pot dictatorship or autocracy. That's no good reason to appoint an acting commissioner of police and violate the Constitution. So this is where the rub is. There was no acting or substantive commissioner of police between August 3rd, 2020 to March 30th, 2022. Mr. Hoppe was simply performing the functions of commissioner of police as per the usual convention and practice, and no attempts were made to appoint Mr. Hoppe or Mr. Hicken or some other qualified person as acting or substantive commissioner of police. And this is what Sheila Al-Prasad said. Sheila Al-Prasad said that when there's no commissioner of police, the next person in line is the person who takes over. And I cross-examined Sheila Al-Prasad on this, and I said to Sheila Al-Prasad this in July of 2017. I said, so apart from that, what is the process that takes place when you go on leave and Assistant Commissioner Ramnarayan assumes your role? And he said, there is a letter from the minister approving leave, and that same letter will indicate that Assistant Commissioner Ramnarayan will act. And I questioned him again, and whose decision it is that Ramnarayan will act? And he said, the Minister of Public Security. I don't know if it goes further than that in the government structure. And then I said, have Mr. Ramnarayan ever given you cause to doubt his suitability to act in the appointment of commissioner when you proceed on leave, whatever form the leave takes? And he said, well, the suitability to act will be the next most senior officer, and no, he was the most senior officer. So he didn't give you any cause to doubt his suitability to act in your position. And hear what Prasad said. Given he's the most senior officer, it is the only consideration. Well, personally, have you ever had cause to doubt his suitability to act in your position? And he said the qualification for that is he is the next most senior officer. I have no doubt he was the next most senior officer. That's the convention in the Guyana Police Force. The Commissioner of Police goes off on pre-retirement leave. The next most senior officer acts in his position or performs the function of the Commissioner of Police until the constitutional requirements are met. So I said the evidence under oath of Commissioner Sheila Al-Prasad remains important as it sets out the process and conventions that exist or existed at the time to ensure that the Guyana Police Force continues to function with someone at the helm. Sheila Al-Prasad's evidence alone absolutely demolishes what President Ali said, or how he claimed to act under the Doctrine of Necessity. And in the circumstances of how the Guyana Police Force operates, Paul Williams, the sole Deputy Commissioner of Police, was next in line to perform the duties of Commissioner of Police upon the departure of Nigel Hoppy on pre-retirement leave, and Rule 35 of the Public Service Commission rules would have applied. Now, if Paul Williams, right, was not available, or if he was unable to perform the functions of Commissioner of Police, then Assistant Commissioner Hicken, being the most senior officer, could have been instructed to perform those functions. But this is what is important. In March 2022, the existence of exceptional circumstances not provided for in the Constitution for immediate actions to be taken to protect or preserve some vital function to the state did not exist. It didn't exist. An acting Commissioner of Police Clifton Hicken appointment was not reasonably necessary in the interest of peace, order, and good governance. Therefore, the common law doctrine of necessity was not available in the circumstance. Now, when in fact the president breached the Constitution in respect to the improper appointment. So, Article 211, subsection 1 of the Constitution states that the Commissioner of Police and every Deputy Commissioner of Police shall be appointed by the President, acting after meaningful consultation with the Leader of the Opposition and Chairperson of the Police Service Commission, after the Chairperson has consulted with other members of the Commission. Now, Article 211, subsection 2 makes the appointment of an acting commissioner subject to the same constitutional requirements as commissioner. So you still got to consult with the Leader of the Opposition meaningfully. You still got to talk to a chair of the Police Service Commission, who will then speak to the entire commission and then give you their rules. So we say that the Constitution is silent on what takes place when and where there's no Police Service Commission and the Leader of the Opposition is absent. So no Police Service Commission, no Leader of the Opposition to ensure meaningful consultation. What is known in this case and has to be factored in the mix is when there existed a Police Service Commission and a Leader of the Opposition, the President was at odds with the Police Service Commission, which he illegally and unconstitutionally suspended, and he blatantly refused to meaningfully consult with the Leader of the Opposition at all. Therefore, in the unusual circumstances here and the opportunities that presented itself in the absence of the two constitutionally mandated officers to which the President was required to consult, it could be assumed that the President opportunistically placed reliance on the common law doctrine outside of what the Constitution allows. I then cited a case called Ghana Bar Association and others versus Attorney General and another, and Sky versus the Attorney General, and Danso Achampong versus Attorney General 2016 5 LRC 443, and that's a decision of Ghana, which says, well, the purpose of a three-tier appointment process in Article 144.2 of advice of the Judicial Council, consultation with the Council of State, and approval of Parliament was part of the constitutional checks and balances on the separation of powers, which is designed to insulate appointment process against excessive executive control and intermeddling, and to act as a restraint on the President's power of appointment and prevent improper appointments. So that's what we had here. We had an improper appointment in Guyana, and the President kind of trying to use the absence of the leader of the opposition and the absence of a police service commission as a crutch. So I said, as noted above, the condition precedent to that invocation of the common law doctrine of necessity was not met in the context of the pre-retirement leave of Deputy Commissioner Nigel Hoppy, who was performing the function of Commissioner of Police that required or necessitated the departure from the conditions set out in Article 211, subsection 2 of the Constitution for the appointment of the acting Commissioner of Police. And then I concluded, I said the factual context, including the social, political, and legal context, had significant bearing on the conclusions I've reached in this matter. The President cannot rely on the doctrine of necessity, as case law has supported the protection and preservation of the country's constitution, while the Constitution of Guyana is silent as to the process to undertake in the absence of constitutional office holders, imperative to such an appointment process contemplated in Article 211 of the Constitution. The evidence reveals the President had no interest in consulting with the leader of the official opposition whilst one was in place between August 2020 and January 2022, and his unconstitutional actions in suspending the Police Service Commission is autocratic. Therefore, the resort to the doctrine of necessity in making this appointment in the absence of a functioning Police Service Commission and the vacancy of the leader of the opposition was opportunistic, ill-advised, in bad faith, and not captured by the circumstances which existed at the material time. And that would have supported the invocation and use of the doctrine of necessity to make the appointment of acting Commissioner of Police. I so advise. And so these are the recommendations. I said the appointment of the acting Commissioner of Police, in my respectful opinion, is manifestly ultra vires Article 211, subsection 2 of the Constitution, unlawful, illegal, premature, and has no legal force, import, or effect. Given the unconstitutional appointment has been made, in the absence of a resignation of Mr. Hicken, or in the absence of the revocation of that appointment by the President, or the appointment of a substantive Commissioner of Police, which in effect revokes or renders spent the appointment of Hicken, it is for the Court of Competent Jurisdiction to adjudicate. An application in the nature of judicial review would be recommended in the circumstances. These matters, as past history would dictate, are complex, time-consuming, expensive, and uncertain. And so that is the opinion that I rendered on the appointment of Mr. Hicken. I mean, these situations, yes, ultra vires. So these situations are quite interesting situations that are being created in Guyana. And it's unfortunate that the advice that the President is getting is bad advice. This is the second time that I pronounced on the President's violation of the Constitution. He did that when he suspended the Police Service Commission. But this President is doing that because he thinks he can get away with it, you see. And like I said, if the President of Guyana is acting so early in his presidency in quite an autocratic manner, in quite a manner that is violative of the Constitution, violative of, the processes that provide for checks and balances, what's going to happen when he reaches his third, fourth, and fifth year? And the president and I are good with each other. Right? The President and I are good with each other. Hicken has been very kind to me, but that doesn't mean that I need to turn a blind eye and ignore the President's violation of the Constitution. You know, to silence is democracy's greatest foe. You know, you keep silent about constitutional violations, they're going to keep going on and on and on. Now, anybody have any questions, having heard me, speak to or pronounce on the appointment of Hicken? So essentially, the appointment of Hicken is going to go away, right? The appointment of Hicken is going to go away in a few weeks, and it's left to be seen whether or not Hicken is appointed the substantive commissioner of police. You know, it's left to be seen. But you know, the good thing about the entire situation with the president and the leader of the opposition is the current administrator, the current Minister of Agriculture, Zulfikar Mustafa. His case at the Caribbean Court of Justice sets out what meaningful consultation means, how it takes place, and what the president has to do to ensure that meaningful consultation takes place and could be sustained on the record, where he's exercising his powers under the Constitution to make appointments where such a requirement has to be met. So that case is very helpful to Aubrey Norton in terms of how the president conducts himself and the power that the leader of the opposition has in respect to an appointment such as that, which is going to be coming up for ventilation in a few days. So we'll see how that goes. It may well be the case that judicially reviewing the Hicken appointment is still important, because if there's no judicial pronouncement on how the president used the doctrine of necessity in this case, you know, if there's no litigation, then, you know, the president may well continue to abuse that prerogative and claim the doctrine of necessity is the basis for which he makes an appointment or revokes an appointment. So that is how I sort of landed on that issue, and it took a lot of thinking to sort of go through that issue. So thanks for those of you who tuned in, and that's what I had to say on this issue. Good morning.